Hello friends, this is Dr. Rohit from Rohit Productions. Well, hope you enjoyed watching my video on company law. And don't forget to subscribe to my channel, Rohit Productions. I'm uploading another video on company law, which is the continuation of the first video. In this video, what we are going to talk about? We are going to talk about the directors. We are going to talk about the accounts, the accountability. We are going to talk about the meetings, the general meeting, the annual general meeting, the statutory meetings. Then we are going to talk about the various aspects of companies, mergers, acquisitions, amalgamations. Further, we'll be talking about the winding up of the company by the tribunal or voluntary winding up, and the National Law Tribunal. These are going to be the various topics which I'll be going to cover in this video. Before starting with this video, let me tell you that there's going to be another video on company law, which is going to be my favorite topic. That's going to be the shares, the capital, debentures, issue of prospectus, and the stock market. So don't forget to miss out my last and my favorite video. So let's now start with the second video of company law. Here we'll be dealing with the directors. So before starting with the directors, the appointment of directors, the qualification of directors, whether directors are trustees or not, how can we disqualify director, what are the powers of a director, what are the duties of a director. Before starting that, let me just let's just start with the directors directly. Before starting with the directors, why do we need to have a director? And how many directors do we need to have? Depends. Okay, so when we are talking about a director, okay, it says the first thing about a director is, as per my notes, it says it's very difficult to define the position of a director of a company, including legal position. The position of the director has been defined as they are appointed to act in the interest of the company. An important area of their legal responsibility stems from the law of trust. They have a fiduciary relationship with their company. So they have a fiduciary relationship with the company. It's basically on trust. And now further, when we're talking about directors, let me start with company 2. So as per section 149, company 2 have board of directors. Every company shall have a board of directors consisting of individuals as directors and shall have a minimum of 3 directors in case of a public company, a minimum of 2 directors in case of a private company, and 1 director in case of a single person company. A woman director if it's prescribed by the scheme of central government. And then further, a company should not have less than 1 director who has stayed in India for a total period of not less than 182 days in the previous calendar year. And every listed public company shall have at least 1/3 of the total number of directors as independent directors. And the central government may prescribe the minimum number of independent directors in case of any class of public companies. So it depends on the class of public companies how many directors they should have, and that is defined by the central government. So further we move on with independent directors. Every listed public company is to have at least 1/3 of the total number of directors as independent directors, and it is defined by the central government. May prescribe the minimum number of independent directors in a class or classes of public companies. So there are various classes of public companies, and the central government defines how many directors they should have, independent directors. So there are various criteria which are being laid down, that they should not have a pecuniary relationship, and then there is some capital which is being given, and furthermore the relatives should not be working over in the same company or associated with that company, and they should not have the director should not have a pecuniary relationship with the company, its holding subsidiary or associate company. So certain conditions which are being laid down. After that, we move on with the next topic, which is regarding the appointment of director elected. Let's get back to this point. Manner of selection of independent directors and maintenance of data bank of independent directors. The appointment of independent directors shall be approved by the company in general meeting as provided in subsection 2 of section 152, and the explanatory statement annexed to the notice of general meeting called to consider the said appointment shall indicate justification for choosing the appointee for appointment as independent director. So it is defined by section 152 subsection 2, that is by the general meeting. And the central government may prescribe the manner and procedure of selection of independent directors who fulfill the qualifications and requirements given under section 149. So the manner and procedure is given by the central government. General meeting is done, and then we select the independent directors. Further move on with the next point, which is very important, is appointment of director elected by small shareholders. A listed company may have one director elected by such small shareholders in such manner and with such terms and conditions as may be prescribed. So according to terms and conditions, a company with small shareholders may select a single director, that is given under section 151. Section 152 defines the appointment of directors. So very important section 152. Let's get back to section 152, which defines about the appointment of directors. So how will we define and how will we appoint the directors? So when we are talking about the appointment of directors, so section 152 says every company shall have a board of directors consisting of individuals or as directors, and shall have minimum number 3 in case of public, 2 in case of private, 1 in case of one person company. Then appointment of the first director. It says where no provision is made in 3 articles of the company for the appointment of the first director, the subscribers of the memorandum who are individuals shall be deemed to be the first directors of the company until the directors are duly appointed. And in case one person company, an individual being member shall be deemed to be the first director until the director or directors are duly appointed by members in accordance with the provisions of this section. Under these articles, the names of the first directors are generally mentioned in the articles, and these persons become the directors of the company. Alternatively, the articles prescribes the method of the appointment. Following the prescribed method, the directors can be appointed. Where the articles of the company are not registered or it does not mention the names of the first directors, the majority of subscribers to the memorandum shall determine the name and the number of directors of the company. So it will be determined by the subscribers of the memorandum, and they shall determine it. So this was regarding the appointment of directors. Furthermore, we can say that no person shall be appointed as a director of a company unless he has been allotted the director identification number under section 154. So 154 section gives the direction identification number to a director. So he will not be appointed as a director unless and until he has been given a director identification number. Every person proposed to be appointed as a director by the company in a general meeting or otherwise shall furnish his director identification number and declaration that he is not disqualified to become a director under this act. A person appointed as a director shall not act as a director unless he gives the consent to hold his office as director, and such consent has been filled and filed with the registrar within 30 days of his appointment in such a manner as may be prescribed. Okay, and then further it says that the directors to retire by rotation at every annual general meeting shall be those who have been longest in the office since their last appointment, but as between persons who became directors on the same day, those who are not to retire in default and subject to any agreement among themselves be determined by. So this was regarding retirement. So unless the articles provide for the retirement of all directors at every annual general meeting, not less than 2/3 of the total number of directors of the public company shall be persons whose period of office is liable to determination by retirement of directors by rotation. So if directors are retired by rotation, so period of office is liable to determination by rotation of directors by rotation. Save as otherwise expressly provided in this act, be appointed by the company in general meeting. The remaining directors in case of such a company shall, in default of and subject to any regulations in the articles of the company, also be appointed by the company in general meeting. So the remaining directors will also be appointed in the general meeting, subject to the articles and regulations of the company. At the first annual general meeting of a public company held next after the date of general meeting at which the first directors are appointed in accordance with the clauses, and every subsequent annual general meeting, 1/3 of such of the directors for the first time being as able to by retire by rotation, or if the number is neither 3 or multiple of 3, then the number nearest to 1/3 shall retire from the office. So this gives the criteria for the retirement of the directors. So we saw about the appointment, we saw about the retirement. Now let's move on with the further point, which is regarding additional director by the director, section 161. So we'll talk about section 161. We'll talk about appointment of additional director, alternate director, or nominee director. So when can we have an additional director? The board of directors of a company may appoint a person as additional director, alternate director, to act in place of a director who is absent for a period of not less than 3 months from the state in which the meetings of the board are ordinarily held. The term of office of an alternate director expires on the return of the original director or expiry of his term of office, whichever is earlier. A director in a casual vacancy created on account of death, resignation, disqualification of a director, we have an additional director. By third parties, we can have it. The articles may provide third parties, that is debenture holders, creditors, or bankers of the company, and appoint their nominees on the board of directors. In such a case, third party can appoint its nominee as the director of the company. By the tribunal may appoint any person as director to prevent operation or mismanagement under section 242 1K of the Companies Act 2013. And the term of such appointee shall not be more than 3 years on any occasion. So, and director identification number is given under section 153 of the Companies Act. Every individual intending to be appointed as director of a company shall make an application for the allotment of director identification number to the central government in such a form and manner along with the fees as may be prescribed. So the director identification number is issued by the central government. So further, we saw about additional directors who can be there in case of resignation, death, casual vacancy, or can be appointed by the tribunal for a period not exceeding 3 years, or can be appointed by third parties for like bankers, creditors, as per their nominee in the board of directors. So now we have seen about the director identification number, we saw about the appointment, we saw about the qualification, we saw about the retirement. Now we'll see about the removal of directors. So how can a director be removed? What can be the possible ways where a director can be removed? Director can be removed, let me just check it. As per section 169, let's say, removal of director. So what can be the special thing if I want to remove a director of the company? So who all people will be there who can help me in removing the director of the company? So first thing would be a company may by ordinary resolution remove a director not being the director by the tribunal under section 242 before the expiry of a period of his office after giving a reasonable opportunity of being heard. So I can remove by special resolution, I can remove a director. Obviously I can remove director, but not a director who has been appointed by the tribunal under section 242. Okay. Then we can have a special notice shall be required of any resolution to remove a director under this section or to appoint somebody in place of a director as removed at the meeting at which he is removed. So special notice is being given shall be required of any resolution to remove a director under this section or to appoint somebody in place of directors so removed. Okay. On receipt of notice, a special resolution to remove a director under this section, the company shall forthwith send a copy thereof to the director concerned, and the director, whether or not he is a member of the company, shall be entitled to be heard on the resolution at the meeting. So on a receipt of notice of a resolution to remove a director under this section, this is section 169, the company shall forthwith send a copy thereof to the director concerned, and the director, whether or not he is a member of the company, shall be entitled to be heard on the resolution at the meeting. So a copy will be sent to the director and the director will be heard on the resolution at the meeting. Where notice has been given of a resolution to remove a director under this section and the director concerned makes with respect thereto representation in writing to the company and requests its notification to the members of the company shall, if the time permits it to do so, in any notice of the resolution given to the members of the company, state the fact of the representation having been made, that he has represented and the fact has been made in the notice, and send a copy of the representation to every member of the company to whom notice of meeting is sent, whether before or after receipt of the representation by the company. Okay, so the company shall send notice or a copy of the representation to every member for whom they have sent the receipt of the representation of the company. And if a copy of the representation is not sent aforesaid due to insufficient time or for the company's default, the director may, without prejudice to his right to be heard orally, require that the representation shall be read out at the meeting. So he'll read out the representation at the meeting. Provided that the copy of the representation need not be sent out and the representation need not be read out at the meeting if on the application either of the company or of any other person who claims to be aggrieved, the tribunal is satisfied that the rights conferred by this subsection are being abused to secure needless publicity for defamatory matter, and the tribunal may order the company's cost on the application to be paid in whole or in part by the director, notwithstanding that he is not a party to it. Okay. Further, a director so appointed shall hold office till date up to which his predecessor would have held office if he had not been removed. So he'll be still holding the office till his next person comes as a director. A vacancy created by the removal of a director under this section may, if he had been appointed by the company in general meeting or by board, be filled by the appointment of another director in his place at the meeting at which he is removed, provided special notice of intended appointment has been given under subsection 2. So there is one more clause to it. Nothing in this section shall be taken as depriving a person removed under section of any compensation or damages payable to him in respect of the termination of his appointment as directors as per the terms of contract or terms of appointment as director, or of any other appointment terminating with that as director, as derogating from any power to remove director under other provisions of this act. So this was all regarding removal of directors. So what are we going to do? We are going to pass a ordinary resolution except for the section 242 or the director who has been appointed by the tribunal. Okay, and then when we give a special notice should be given and that resolution, and to remove a director and appoint someone else. On receipt of the notice of resolution to remove director, the company shall send a copy to the director and to the members of the company. When notice has been given for the resolution, the director will be heard and he can make in writing and he can give a representation in writing to the company and request its notification to the members of the company. And further, in any notice of the resolution given to the members of the company, state that the fact of representation having been made, send a copy of the representation to every member of the company to whom the notice of the meeting is being sent. Okay, so this was all regarding, and he'll hold the office till the next person who has been appointed as a director comes. So this was regarding removal of the directors. So what are the further we move? Let us just watch about let's talk about a further point, which is regarding disqualification of directors. Disqualification of directors, which is given under section 164. So disqualification of appointment of director. If he's an undischarged insolvent, he's of unsound mind and stands so declared by competent court, he is applied to be advocated as an insolvent and his application is pending, or he has been convicted by a court of any offence whether involving moral turpitude or otherwise, and sentenced in respect thereof to imprisonment of not less than 6 months and a period of 5 years has not elapsed from the date of expiry of the sentence. So within that 5 years, you are not appointed, disqualified, if he has been convicted. Provided that the person has been convicted of any offence and sentenced in respect thereto to imprisonment for a period of 7 years or more, he shall not be eligible to be appointed as the director of any company. An order disqualifying him for appointment as a director has been passed by a court or tribunal, and the order therefore is in force. He has not paid any calls in respect of any shares of the company held by him, whether alone or jointly with others, and 6 months have elapsed from the last day fixed for the payment of the call, and he has been convicted of the offence dealing with related party transactions under section 188 at any time during the preceding last 5 years, or he has not complied with subsection 3 of section 152. So what is subsection 3 of section 152? Subsection 3 of section 152 deals with no person shall be appointed as a director of the company unless he has been allotted a director identification number as per section 154. So if he doesn't have a director identification number, he is disqualified for appointment of a director. So next we move on. Appointment of directors to be voted individually. At a general meeting of the company, a motion of appointment of 2 or more persons as directors of the company by single resolution shall not be moved unless a proposal to such a motion has been agreed to the meeting without any vote being cast against it. A resolution moved in contravention of subsection 1 shall be void, whether or not any object was taken when it was moved. Motion for approving a person for appointment or for nominating a person for appointment as a director shall be treated as a motion for his appointment. So section 162 lays down about a general meeting where a resolution has been made or a motion has been approved for making a person a director. Moved in contravention of subsection 1 shall be void, whether or not any object was taken when it was removed. So this was all regarding the appointment to be voted individually. So now we move on with the next point, which we are saying is as what is the difference between an appointment of a director and when we appoint a director, and the difference between when we have a trustee. So many people always ask me what is the difference between a trustee and a director. So let me just have my notes. I made a little bit of points to remember between a director and a trustee. So we're talking about directors occupy fiduciary position in respect to the company of which they are directors. They are also to some extent trustees for the company. However, they are not trustees. Okay. Time people ask me regarding whether the directors and the trustees are the same boots. So let me just have a clarification for this. Where what I see is that trustees of a company's money and property. Okay, they are the trustees of a company's money and property in the sense that they must account for all the company's money and property over which they exercise control. They also have to refund to the company any of its money and property which they have improperly paid away. They are, however, not trustees in the real sense of the word because they are not vested with the ownership of the company's property. It is only as regards some of the obligations to the company and certain powers that they are regarded as trustees of the company. Well, what are trustees of the company? What are the powers of the trustees of powers entrusted to them? Okay, They are trustees of the powers entrusted to them, in the sense that they must exercise their powers honestly and in the interest of the company and the shareholders, and not in their own interest. Directors are trustees of the company and not for the individual shareholders. Further, they are not trustees for third person who have made contracts for the company. Although directors are loosely called trustees, they are not trustees in the strict sense of the term. The correct view is that they stand in a fiduciary relationship to the company, and they are really only quasi-trustees because the company's money and property are not vested in them, but not in the company. Their functions are not the same as those of the trustee, and their duties of care are not as onerous as those of the trustees. So this makes sense, where we find the difference between the trustees and the directors. Now we move on to the next topic, where we're talking about the various duties of a director. Well, talking about the duties of the director, section 166 says that, subject to the provisions of this act, the director of a company shall act in accordance with the articles of the company. So he'll have to act in accordance with the articles which are being prescribed in the company. So a director of a company shall act in good faith in order to promote the objects of the company for the benefit of its members as a whole and in the best interest of the company, its employees, its shareholders, the community, and for the protection of the environment. Director of the company shall exercise his duties with due and reasonable care, skill, diligence, and shall exercise independent judgment. A director of the company shall not involve in a situation in which he may have direct or indirect interest that conflicts or possibly may conflict with the interests of the company. A director of a company shall not achieve or attempt to achieve any undue gain or advantage either to himself or to his relatives, partners, or associates, and if the director is found guilty of making any undue gain, he shall be liable to pay an amount equal to that gain of the company. The director of a company shall not assign his office or any assignment so made shall be void. If the director of a company contravenes the provisions of this section, such director shall be punishable with fine, which shall not be less than 1 lakh rupees, but which may extend to about 5 lakh rupees. So this was regarding the duties of the director, which we saw: good faith, due skill, reasonable care, skill. Then he should not have anything which is apart from which is in conflict with the interests of the companies. Then director of a company shall not achieve or attempt to achieve any undue gain or advantage. Further, he should not assign something to someone else which will make it void. His office or any assignments to someone else is not in a position to handle it. If a position of a company contravenes the provisions of this section, so the director shall be punishable with a fine, which is around 1 lakh to 5 lakh rupees. Vacation of office of director, section 167. The office of director shall become vacant in case he incurs any of the disqualifications as in section 164. He absents himself from all meetings of the board of directors during the period of 12 months or without seeking leave of absence of the board. He acts in contraventions of the provisions of section 184. He acts in contraventions of the provisions of section 184 relating to entering into contracts or arrangements in which he is directly or indirectly interested, and he fails to disclose his interest in any contract or arrangement in which he is directly or indirectly interested in the contraventions of the provisions of section 184. Or he becomes disqualified by an order of the court or tribunal, or is convicted by a court of any offence, whether involving moral turpitude or otherwise, and sentenced in respect thereto to imprisonment of not less than 6 months. And provided that the office shall be vacated by the director, even if he has filed an appeal against the order of such court, he is removed in pursuance of this act, and he, having been appointed as director by virtue of his company, any office or the employment, the holding, subsidiary or associate company, ceases to hold such office or the employment in that company. So this was regarding the vacation of office of director. So now we saw everything about qualification, right from power, right from appointment, right from removal. Then we saw about directors as agents, powers, Now we see about punishment as per section 172, which says if a company contravenes any of the provisions of this chapter for which no specific punishment is provided therein, the company and every officer of the company who is in default shall be punishable with fine and which shall not be less than 50,000 rupees, but which makes into 5 lakh rupees. So 50,000 to 5 lakh is the fine. If a company contravenes any of the provisions of this chapter and for which no specific punishment is provided therein, the company and every officer of the company who is in default shall be punishable. So if company or its members are at default, they are punishable for a fine from 50,000 to 5 lakh rupees. Regarding the appointment of directors, the qualification of directors, the removal of directors, the duties of directors, and directors as trustees and not. So let's move on with the other topics now. Hope you enjoyed watching this video on directors and their qualification and powers. Let's move on with the other section of the video.